All right, everybody, welcome. I'm sure more people are trickling in. Our attendance is a little bit lighter today, but that's okay. I assume, it's midterms. We're approaching spring break. Most of us can barely function. So I want you, though, in your pre-spring break fog to really have some good questions for Professor Dickinson. So really think about them, write them down, and be ready. We'll do the same format we often do. He'll present for about 15, 20 minutes. And then you all will grill him. We will not do a queue. You just raise your hands and he'll call on you. Let me introduce Professor Dickinson, then I'll get out of the way. Gregory M. Dickinson is an assistant professor of law and, by courtesy, computer science at the University of Nebraska, where he teaches unfair competition, the common law, contracts, and remedies. He is also a non-resident fellow at the Stanford Law School program in Law, Science, and Technology, and the Murray and Polly Bowden Fellows program at the University of Texas School of Law. He holds a JD from Harvard Law School. Professor Dickinson's research focuses on the interaction between private law and technology. And I would just say his topic today is incredibly timely. One of the big things I think about as a First Amendment scholar is how do we properly regulate things like social media and AI when they so often intersect with First Amendment rights? And what are the ways we can think about that? Are there ways to regulate these technologies without violating so many of our norms related to the First Amendment? These are great pressing questions, probably the most pressing questions in the First Amendment space, and thankful to have him here talking about those and other issues that he's working on. Lastly, I'll say I first met Professor Dickinson at Stanford Law School, and we would have had a chance to get to know each other much better, but about a month after we started meeting one another, the pandemic hit, and we had to flee to our homes and didn't get to talk to each other as much. So, Greg, welcome. Glad to have you here. Thank you.
All right, so thank you all for being here. It's a real pleasure, especially coming from Nebraska. It's freezing cold where I live often, and yet I got a little more than I bargained for when I came here. Again, good to see you all. As Steve mentioned, my work touches on two things that some people find a little odd. One part of my work focuses on law and technology. The other maybe half of my work focuses on the common law. And so I like the new techie stuff and I like the old dusty stuff. And so that can be a little confusing to some, but I hope by the end of our 20 minutes today, you'll see why I find the two important to consider together. And maybe I'll convince you to like some of the old stuff too. The central claim of the paper, I assume some of you will have had a chance to look at it, some of you will not have. But the central claim is that they're a very natural response are technology-specific statutes. When we hit a new technology or it hits us, what do? You want to regulate it and make sure it doesn't hurt you. But that natural response often does more harm than good. And I want to walk through a couple of examples to show you what I mean. And then the bottom line conclusion of the piece is, well, that's okay. It's okay that statutes are often counterproductive because we have the common law and general law that we can fall back onto, and many times that can do just as good of a job or better than any particular statute we might have designed. So we'll go through a couple examples of the impulse to regulate new technology with statutes. We'll talk about why that often can be counterproductive, and then we'll talk about hopefully a few ways that general law can actually account for new technologies without any new specific statutes. So the general theme that I want to talk about, or the recurring pattern in history, you see it all the time. And after we talk through it today, you'll see it everywhere. You start, when there's a new technology, you start by saying, wow, that's amazing. I remember the first time I talked to my phone and thought, wow, how is this even possible? This is amazing. Then we start to fear it and say, wow, this is really powerful. It could hurt somebody. And then almost invariably, the next step is to regulate it. And we can immediately see why that would be the natural human progression. I don't mean to denigrate it. I do it myself. And yet by noticing it, we can perhaps respond to it better. The way I'll talk about this is in terms of media history or the history of media regulation, because that's a place where it's particularly easy to see. And maybe I don't want to call it the biggest invention of all time. I'm not qualified to make a claim like that. But imagine the printing press. You go from it takes a monk with a candle, or actually you weren't allowed to use candles as a monk because you might burn a book that's more valuable than you are just about. But you're a monk, you're writing down books by hand, and then all of a sudden they can be printed with a printing press, an amazingly powerful invention. And the church's initial response and the public's initial response was amazement. The church initially called it a divine art, the art of book printing. But before long, they started to worry, or the kings and the leaders of the church started to worry, well, this could, and it's tempting in retrospect to say they were worried about power. And we would say they were worried about power in some sense. But think about what was in the mind of a king or a spiritual leader at the time. It wasn't, I must retain power, or at least we would think as humans that's hopefully not a naked ambition, wasn't what they were thinking, but probably to some extent good-natured. It's the danger of the spiritual health of the people who could be harmed by counterproductive works of literature. You would hope that church leaders at the time had some concern for the people, and that was part of the motivation. And for political leaders, maybe there was some ambition involved, but maybe, well, what's going to happen? Is there going to be chaos rather than law and order if the printing press is allowed to continue freely? And so I just want you to see that it's not malicious lawmaking that causes things that we see as problems in retrospect. It's often well-meaning lawmaking. Some more modern examples that are really where I want to spend more of the time. This is a quote in the Brooklyn Eagle from 1899. Let me see. I won't tell you what it's about at first, but I just want to read it to you. Again, 1899. The number of people who think like birds in little broken thoughts will greatly be enlarged. Millions upon millions of American boys and girls and men and women will be, like their English cousins, unable to learn anything, unable to know anything well, and to concentrate their minds on anything. I don't know why the hate for our English cousins, but apart from that, it sounds like you could be talking about smartphones or something. And yet, what's that about? That's about magazines in 1899. The magazine publication this was under the title Newest Fads in Publishing. There was this fear of magazines causing the same sorts of harms we worry about with smartphones today. Then another quote I want to read to you just to get the sense. This is about novels, and this is an 18th century quote. And the concern was for the health of young women, that they would stop being industrious in their labors and start to have social ambitions outside their class. A cause of the profligacy of the present age is that mass of novels and romances which devour people of all ages. This is a new species of entertainment, a great mark of frivolousness and effeminacy. Such as devote their time to this species of reading are seldom capable of attending to books where solid instruction is conveyed. Many young girls, from morning to night, hang over this pestiferous reading to the neglect of industry, health, proper exercise, and to the ruin of body and soul. And so the point of this, I don't hate the novel. I love novels. They're lots of fun. But my point is, it's kind of a recurring theme in media technology, and indeed all forms of technology, to become nervous about it. It's world changing, or the technology's world changing nature is obvious from the very beginning often, and that's scary because folks in power can't predict where the new direction will go, and they often fear for the worst. And so that is novels. The last one I'll mention briefly, because I want to talk about also technology or kind of non-media technology, is the elevator. The first elevators, people were so scared of them that they couldn't get anybody to ride them. They were installed in a department store, was one of their first usages, and so scary that legislatures responded with hyper-detailed regulations about how old an operator had to be, whether the operator could be a man or a woman. It typically had to be a man, although there were some occasions when women could do it, and limiting the speed of elevators to a few miles per hour, about 2 miles per hour. Of course, we can see now, not that these were necessarily wrong, but we can certainly see that that's quickly going to become outdated when instead of requiring that elevators be safe or imposing liability for any crashes, you're saying the rope needs to have X strength, it needs to be operated by this or that union member, or it needs to move no faster than X miles per hour. Just another example, there are many, many examples of this. And each time it happens, the law is invoked to protect the status quo, or created to protect the status quo in a sense, and to protect the public from itself. But when we look back in retrospect, often it was also designed or also accomplished the fact of keeping current powers in power, whether it be union member men restricting the ability of women to operate elevators, or whether it be the aristocrats and royalty restricting the ability of the populace to read matter from a printing press or magazine. And so often in retrospect, it's easier to see the harm than going forward. And yet, I suspect naturally the impulse still is, well, we've got to do something, right? We've got to do something when new technology enters the scene. And I want to push back on that a little bit. I won't say that's always wrong, but I want to push back a little bit and think about this. Think about the law of assault or battery or contract. There's a reason that it's been unlawful pretty much forever to assault and batter people. One of my favorite cases when I teach torts, those of you who are law students may have read it, there's a man who, I guess he really needs a drink, starts battering on an innkeeper's door at night after closing. His wife sticks her head out and yells for the banging to stop, and the man who wants a drink very badly has a hatchet that he swings at the innkeeper's wife. Unsurprisingly, even in, I think it was the 1300s, that case was decided, you weren't allowed to do that then either. And the reason the law is so long-standing in that area is, well, the reason you're not supposed to do that is you're not supposed to hurt people, and you're not supposed to put people in apprehension of harm, because we have this view that, well, you shouldn't do that. You shouldn't harm people or threaten to take their life or their health, which is a species of their property interest. And so it doesn't matter what technology is at issue. It doesn't matter if it's a hatchet, a sword, a taser. It doesn't matter what you've got. The law doesn't really need to change. I mention that because, well, often that's true with more modern technologies too, in other areas where the law is already in place because we have known for a long time that you shouldn't do that sort of stuff, and the law can be technology agnostic. And so to give a few examples, one that has, I guess, bothered me a lot because I'm so worried about the harms it could do. I hate dark patterns. You may have run into this term. This is things like you're trying to check out and you have to create a new shopping cart account or something like that. And there at the bottom, you notice in like a barely visible font color, yes, please do send me daily emails from your marketing team. And you're like, wait, why was that the default? Why was that pre-selected? That's the idea of a dark pattern. My favorite one, I just can't help mentioning it every time I talk about these. Another instance of kind of consumer deception is there was a case by the FTC against a company accused of endorsing a fake Kim Kardashian endorsed colon cleanser. I remember seeing this. This is amazing. If I wanted a colon cleanser, I guess I would go with whatever Kimmy K had to say. But I'm skeptical that she endorsed one, and sure enough, she didn't. And my point is, these are fun cases, but it has been unlawful almost as long as it has been unlawful to hit people with hatchets, to lie to them and trick them out of their money. And also for a very long time since the 1930s Wheeler Act amendment to the FTC Act, it has been unlawful to just confuse people in a way that's likely to deceive them as to the nature of goods that you're selling. We have a lot of law about this already. And so automatically recurring subscriptions that aren't properly labeled, deep fakes on the internet with fake endorsement videos, all of this stuff can seem scary and like it could get out of hand, and it could. But I want to use this set of cases to reiterate that very often the law is already in place, and it's just about finding the enforcement resources, not about writing a new statute. And so I want to reiterate that point. The last point I want to make is you may still be thinking, if maybe I've convinced you, maybe not, but you may still be thinking, well, it couldn't do any harm. We've got this great general law base of common law and really broad statutory law, but maybe we need to push it along a little bit with a statute, make it come up to the times a little quicker. And I'm not entirely averse to that. I think that can be appropriate sometimes, but I want to mention some of the dangers. There's some real risks of doing this. And I'll just mention two because we have just a few more minutes in closing. The general area here, I think of Game of Thrones. It's not outdated. They have so many spinoffs. Game of Thrones will never be outdated. But there's this saying: the night is dark and full of terrors. The legislative process, I want to say, is dark and full of terrors, and you should be nervous about them anytime you're advocating for text-specific legislation. And a couple reasons why. One of them is that regulators are always working at a knowledge deficit. It's I want to say, literally impossible, or nearly so, to know everything you would need to know to make sensible legislation. And the example I like to use to get you thinking about this is, think about alcohol. Alcohol has been talked about. I went back just for fun to see what Plato had to say about alcohol. And he says he has about as much knowledge as we do. He seems to think, well, alcohol is a gift from the gods. It can be great for conversation and social gatherings, but boy, does it do a number on you if you have too much. And if you look at current health guidance, you see kind of the same sense of, well, we don't really know. It has good effects on the heart, potentially. It causes bad effects in the area of oral cancer and other areas. On balance, we aren't sure. And that is about something that we have been studying literally forever, or nearly forever, and actually have quite good data on. And yet you think, well, if we're asking questions, to go back to Professor Collis's point, we're asking questions about maybe banning social media use among youth. How much do we know about that? We can guess that there's going to be harms, but how much pleasure are they getting out of it? How much will their social connections be changed? Maybe they would have had 10 friends that they won't have now. It's really hard to calculate that stuff. And so the point is, be really careful, because there's a whole lot you don't know. And the last point I'll mention is the danger of regulatory capture. And the point I want to make about this is that it doesn't have to be malicious. I remember in law school, I heard the word regulatory capture, and I thought, well, we got to kick them out of there, kick them out of the castle of the agency, and then we don't have regulatory capture anymore. But it's not quite like that. There's not devious guys like rubbing their fingers together and thinking about infiltrating the agency and biasing the law in their direction. This stuff's really hard. If you're going to write a law regulating AI algorithms, I studied computer science. That was my area of expertise, and I worked as a computer programmer. I couldn't write a law, and I'm a lawyer. I couldn't write a law about regulating algorithms. I would have to talk to Google. I would go and I would talk to their guys and say, tell me about how this works so that I can regulate it efficiently. And just the fact of not knowing and necessarily needing to talk with the experts who know about this stuff, that itself can bias legislation before you even get to the fact that entities like Google have much more concentrated interests than does the dispersed public in having the law in their favor. And so regulatory capture, a very real danger that isn't even, it doesn't even need maliciousness to occur. And that's on the table every time you start crafting new legislation. Everyone who's going to be affected by it is naturally going to want kind of their hands involved in it, maybe for the worse. And so this is my basic thoughts, but I would love to have your comments and questions. We can talk about it some more.
All right, as usual, we just raise your hands and Professor Dickinson will call on folks. Don't neglect one side of the room for the other. And there we go. People have questions?
Yeah.
So I'm curious, you make a lot of analogies, and I think one main difference in my mind between AI and a lot of other historical technological developments is just the adoption curve of how quickly it has become mainstream. Like, for example, I don't have the exact numbers, but just like just how quickly like ChatGPT from release became a very mainstream and very popular, widely used application compared to like other technologies where over several years there might be like common law and time to develop for it. So considering that difference, like how do you think about that, and like how do you think about like addressing that difference and how we need to approach regulation of AI, or do you think do you still think, you know, there doesn't really need to be a difference?
Yeah, so this is a very good point. One reason you could want legislation in a particular area is if you're worried that in one particular area courts won't be able to keep up. There won't be enough adjudication, there won't be enough common lawmaking to keep up. You have a massive societal change, and so, well, let's get it taken care of upfront by a legislature. Here, I don't know that that's going to work because you have this knowledge problem. I think it's going to be very difficult for regulators or lawmakers to make intelligent regulation with any level of specificity. But in an area where what was most important was some sort of clarity about the restrictions, maybe some sort of a disclosure regime or something like that, I could imagine it being useful for a legislator to get out front. But with the questions that I've seen so far, I think adjudication individually, at least at first, and until some sort of stable body of law has evolved a bit, is the better way to go. Yeah.
Hi, Professor Dickinson. Thank you for being here today. My name is Sheila Lawani. I'm not a JD student, but I am at the Moody College of Communication. I very much appreciated your article. In fact, it's in my dissertation.
Oh, wonderful.
I wanted to ask you about, in your article, you really focus on the law, but my dissertation is on the European Union and its media system. And so I do a critical analysis of anti-spyware regulation found through the European Media Freedom Act. And through interviews that I've had with journalists as well as policymakers, there was a sentiment that this law was necessary because it gave awareness to the perniciousness of spyware use against journalists. At the same time, in my dissertation, I argue that existing law is actually sufficient to take care of this problem. This is not a legal question. It's more of a political question and a social question that I have. How do you address a problem like malware when legislators are panicked about it, journalists feel that they're being threatened by it, but at the same time, a new law like the European Media Freedom Act is at risk of being dead letter law, and it seemed like it was much ado about nothing. How do you respond in those cases?
Yeah, so I'll have to preface this by saying that's not a law that I'm familiar with, and so I won't be able to give detailed thoughts on that particular kind of regime and the response. But what I would say is when you have harms that are caused to consumers or any other entity that they're not aware of, somebody has been installing spyware on your system that you don't know about, you're not going to sue about it. You're not going to sue them for fraud if you don't even know it's lurking on your system. And so there are categories of harms that have been long recognized as harms, but cannot be handled by private litigation by the individuals affected. Very often in the U.S. system, which I'm more familiar with, an FTC governmental enforcement action is the way that that's typically handled, because the FTC can sue kind of on behalf of all Americans who have been affected by this without the need to satisfy the usual like class action requirements. And so that's the sort of solution that I'm familiar with, which might map on to what was already in place in the EU, but that I'm not sure of.
Thank you.
Yeah.
I understood the analogy about the hatchet and you're kind of there are underlying principles that then we can simply apply to the new technology. But I guess I'm wondering if sometimes the change in technology can be so consequential that it actually also causes some of those underlying principles to change. I'm thinking, for example, of there's a kind of underlying assumption with like free speech law, for example, that like the reason we restrict the government but not private individuals in restricting speech is like a balance of power with certain technologies like social media. To some extent, like Google and Facebook have more power over the public square than even the government does. Does that factor into how we should think about regulating those technologies because they change the underlying principles? And then if so, like how do we decide when that change is enough to merit?
Yeah. So I think if you have a present desire to deviate from what has been the existing law, and the common law gives us kind of as you might imagine from coming from England and being adopted into the early American courts, it gives us a kind of a private rights libertarian type baseline. And so if you're looking to deviate that, now I'm giving you a much more general answer than the First Amendment, but if you're looking to deviate from what the existing general law baseline is, you might need legislation to do that. Now we have to be careful with that because that could be a way to smuggle in change that maybe particular interest groups want, but the general public would not. But if what you're looking for is kind of legitimate change in response to technological change that has changed the necessary underlying legal structure, I think you might be right. And the sorts of examples I can think of for that, I think of like allocation of radio frequencies. We didn't have any of that before, and so we needed some way to organize it when all of a sudden we had radio. And the same sort of thing with the invention of the airplane. And the old doctrine from your property class, ad caelum, to the heavens, your property went all the way up to the sky. Well, how are we going to deal with that? How are we going to fly our airplanes if you own everything up to outer space from your property? And so we need some system that essentially takes that property right without the usual requirements of property law. And I could imagine the same thing being true in First Amendment context that you alluded to. Those aren't debates that I kind of am up to speed enough on to comment intelligibly, although I think there are good arguments there. But I don't want to commit myself any more than that. But very good point. Yeah.
One thing that I'm thinking about lately in terms of particular AI is there's sort of been the early days of proliferation of people that are like falling in love with AI or seeing AI.
Like literally falling in love?
Yeah.
Yeah.
And, obviously you can make an analogy to like novels or whatever, people reading romance novels or being engaged in like frivolous activity or non-productive activity. But there's a possibility that that type of relationship is exploitative in a way which is a new harm that hasn't been conceived. And maybe it's not a harm that's concentrated on one person, but rather mild on a bunch of people, like an environmental pollution type situation. And so my fear is that if you rely on the common law, it'll just be too slow, especially because judges have the same sort of information deficits that legislators have, as well as the general public. So in terms of development of new harm, do you anticipate that judges will be able to react in time to address possible harms, relying on simple analogies to tort law principles?
Yeah. So actually, I tend to view it the opposite of the way that you did. The way you expressed, I think, is the natural way to view it. But I'll see if I can persuade you there's another perspective, even if I don't convince you that mine is the right one. And that is when you're a legislator, your job is to kind of imagine every possible use case of a technology, every possible factual scenario, and explain what should happen when that occurs. And now you could do it at a really high level of generality and make it possible, but still that's a big ask. Whereas if you're a judge and you're asked to apply the law, you know, whatever that is in your particular area, at least the facts will hold still for you. You've got one set of facts. This particular thing happened, and you're trying to decide whether that's lawful versus unlawful, rather than trying to foresee everything that could happen and prescribe in advance whether that's lawful or unlawful. So I think judges are actually, compared to legislators, in a comparatively good position to resolve the disputes. Now, whether they move fast enough, you need lawsuits about it, but presumably if the harms are real, you'll get those. And so I think there's a real opportunity for judges here. The point about harms, I think they are. I think these are traditional harms, unless I'm missing the point, because there's some tragic cases out there. There's the most famous ones I can think of. There's a guy who had some mental health issues that were known, that came to believe, I don't know how, but came to believe that there was a foreign spy agency watching him through his home printer, somehow aided by his mother. And he ended up murdering her after having talked with ChatGPT for a while, or Gemini, I don't remember which. And the chat bot kind of said, yeah, maybe she is doing that. Maybe you ought to look into this, that kind of stuff. And so to take that as an example, I think we could use normal principles of tort law or products liability law to handle that. We could look at it under a negligence regime and say, was there less care than there should reasonably have been in the creation of this? Maybe. Maybe there's a way to kind of block talk of physical harm to people if that was involved. The other set of doctrines that could maybe handle something like this is re ipsa loquitur, or maybe products liability, strict liability kind of thing. Now, none of this has been applied yet, and so I don't mean to be claiming that the solution is already out there, but the tools are there, and judges could solve some problems like this with those tools. Did you find that persuasive, that the injuries are the same, or did you mean like some different category of injuries?
Well, I mean, you can call me conservative, but I don't think people should be like falling in love with their computers.
Oh, so a harm from the technology being created that's so attractive, you might fall in love with it.
Yeah, well, I mean, it's obviously an excessive and situation, but in terms of like the pernicious effects of the proliferation of social media, obviously we can argue about the exact data, but there's pretty clear relationship between 2015 and the proliferation of Instagram and mental health outcomes among young women. You know, and that's not necessarily something that you can address using tort law, I don't think. And so it either requires regulation or requires the development of a new type of harm to prevent that.
Yeah, so I see what you mean, and this would be an instance where you might need a legislature to create the right, or create the property interest that then existing law would protect. If you have a right not to be seduced by technology, or you know, you have a property right in something like that in your self-esteem, then existing legal structures could theoretically handle it. It'd be an unusual way. Usually the law doesn't handle things by creating new property rights that are then enforced by tort, but you could, in theory, if that's what you wanted. The restriction would be, you'd have to be sure you really wanted that, because it'd be easy with one technology in mind to say we ought to stop lovers of this sort. But then if you create a right to not be seduced by technology, what about stuffed animals? Did you all of a sudden accidentally regulate stuffed animals? I thought they were adorable when I was a kid. And so I want to say, not that you're wrong, but it would encourage useful thinking about whether we're really serious about creating a right like that, or whether we just don't like this new scary bit of technology. Yeah.
What would you say to the view that maybe these new technologies aren't creating new kinds of harms, but perhaps they're accelerating the rate at which harms occur, that might require new unique legislative solutions? One example I was thinking about was with AI, there's a lot of intellectual property concerns on how the models were trained initially, or at least a little I understand. But that use of intellectual property is so rapid and so like kind of maybe hard to discern. Is that different than like previous instances where people are just, copying or making use of stuff that they shouldn't?
Yeah, I think I think to answer the initial question as you started to pose it, I think it's a difference in degree rather than in kind. But that doesn't mean it's not a big deal. And so you mentioned maybe alleged violations of intellectual property laws by the makers of these large language models that like suck up all of the internet and then turn it into really cool stuff. So that's the example you gave. The example that I started to discuss earlier is things like dark patterns or deepfake videos. Those maybe aren't any trickier than a con artist who's really good at his job, but it sure is easier to make a deep fake than it is to become a master con artist. And so maybe it proliferates more. And the point or the way I tend to see that is that means we might need more enforcement resources if it becomes easier to do this stuff. Not necessarily that we need new law, because the new law could be quite counterproductive if it impedes innovation or leads to regulatory capture or something. But I think you're right. Technology can definitely fast track old-fashioned wrongs. Yeah.
Is there any sort of democracy argument to be made that even if people want regulation and they want it now, and they don't care if it's intelligent regulation or unintelligent regulation, they just want to put the brakes on? Why should we disfavor that? And why should we disfavor keeping the status quo instead of launching forward into this new uncertain future?
Yeah.
And what's the problem with slowing down a little bit, even if it does impose some sort of costs in the short term? It means we have more control and more certainty over the direction the technology takes.
Yeah. So I love the question. It's kind of, well, even granting Professor Dickinson that this regulation might produce bad outcomes in the sense that maybe we're going to get impeded innovation. We won't get good things as fast. Democracy picked it. The legislature did it. And so we ought to respect that. Am I characterizing your point fairly? I don't want to like stuff words back into your mouth. And so it's an important point. And it's the reason that I mentioned the worry not only about kind of Hayek's knowledge problem and whether we actually know stuff, but also the fear of legislative capture. Because when you're in a world where legislative capture or regulatory capture is likely, you're actually not getting a kind of a pure feed through of democratic preferences to legislation. You're getting very often concentrated special interest group preferences for legislation. And so I guess a way of me dodging the question and saying, I don't believe you're hypothetical. I don't believe it is democracy versus progress. I think it's actually special interests versus progress. That's one way of answering it is I'm really nervous about regulatory capture. The other potential answer, I suppose, for somebody with a more natural rights bent would be to say, well, I see in the Constitution, or I see in natural rights law, the right to not have your property unduly restricted. And so that would be an argument that democratic interests still aren't allowed to take my right to use my property as I see fit. But of course, that's not actually the constitutional system we live in. That would be more of a political theory argument. But I like the question. It's very well put. Yeah.
So, what does regulate or possibility of regulating technology look like? And that technology is being used to concentrate power and knowledge information. And for example, Oracle has acquired multiple contracts with how entertainment industries will get interested kind of build out the database in their AI, but also then I got the contracts with those contracts of and to me, all this BS keeps the intentions of those who run big tech, but I fear that there is a certain inspiration to concentrate that power and knowledge because of the ways that they go about acquiring AI and developing.
So I may need to ask you to say a little bit more, but let me try to answer it at first. I think there is going to be an impulse, a natural kind of profit-making impulse If you've got some arrangement with the government where you can get access to data that other people don't have, that's going to be valuable to you. And if you can keep it just you, well, all the better than if it's just you rather than public data. But I think there might have been something deeper to your question. I want to make sure I really answered it. Is there something to add?
It's just the concern of that concentration of power and knowledge to like big tech companies and what that means for different aspects and sectors of society when those tech companies will initially be producing knowledge that infiltrate not just the Department of Defense or medicine, but the way that we use our phones and the way that we interact with
Yeah, so two thoughts that maybe you'll find interesting. I can't solve anything, but maybe interesting. The one is I think you're onto something as kind of a particular instantiation of the regulatory capture worry. Naturally, if you're the government and you're trying to figure out how to do something, you're going to want to talk with powerful entities in the space. I remember Oracle being talked to as a potential buyer of TikTok, and so that may be related to what you're referencing. Naturally, if the government comes and asks you how to do something, you're going to say, well, you talk to me, that's how you do it. I'll help you get that done. And so again, it doesn't have to be nefarious to be bad for the public. It can just be people kind of doing what they would naturally say is, yeah, I can take care of that for you. And so that's one bad outcome and one instance of regulatory capture. The other is to kind of tie it back with the point about new rights. We don't currently have something like this, but we may in the future decide that artificial intelligence and big data combined are so powerful that we really ought to recognize some new right. Maybe it would have to be an inalienable right. You can't contract away your right to privacy. People just aren't allowed to mess with your data like that. And so to accomplish an objective like that, privacy, right creation could be a useful way to go about that once we decided we wanted to. Yeah.
You've spoken a little bit about your almost like suspicion of the legislative process, and I think that suspicion is probably well founded. But you talked about, you mentioned like the regulation of elevators and things like that as examples of bad regulatory capture. But when I'm thinking about regulation of AI or regulation of social media, to me, the obvious historical analog is Section 230, which I think most people see as like a resounding legislative success, such that it's called like the 26th word that created the internet or whatever.
Joseph's book, yeah.
Yeah, do you think that, I mean, I wonder what your thoughts are on Section 230. I guess that's not too broad of a question.
Yeah, no, I won't say I love 230 because I think it has flaws, but it's a very good statute. It's close to perfect, and that's if you define perfect by Professor Dickinson, which most people don't. And so regarding 230, just to catch everybody up, it's a law that says something like, if you're an online entity, you'll be liable for stuff your users or other people say only if you said it. You won't be liable in general for things that they said unless you made it your own in some way. And so that's 230. It's an example, I think, of a technology regulation that was not the product of capture. The internet was fairly unimportant at the time that statute was created, and its effects, the way it's been interpreted, would have been unpredictable. Nobody thought it meant what it's come to mean now when it was enacted, and so it's not a target. It wasn't a target of capture, and so that kind of answers the first point. And also, it kind of mirrors the common law. It is a very narrow departure from the common law before it. It's written at a very high level of generality. It says something like, no internet provider or no provider of online services shall be liable for the content created by another content provider. When you're speaking at that level of generality, you're doing the sort of general lawmaking that is similar to the common law and can avoid some of these problems that I'm worried about. So I really like the example. If you want to chat with me after, I'll tell you about my little quibbles that I don't like, but it's a good example of a kind of a broad level statute. Yeah.
Is there not then an argument for advocating for regulation that has a similar level of generality but specifically regarding things like AI and other fastly developing technologies, just with the thought that maybe that will make the legal process go a little quicker, make it easier for judges if they're not having to extend existing harms to new technologies, as we have general statutes.
Yeah. So I could imagine it. Now I want to be careful because even at the level of like all AI, we're already pretty specific because we're talking about just AI and not, you know, stuffed animals and bunny rabbits and stuff. Just AI. And so that could be already too particular because you could end up with an odd divergence between AI and machines that do maybe similar things but are mechanical rather than electronic. You can worry about incoherence in the law that way. But that said, you show me a couple of statutes, one that talks about AI generally and one like a bill that was introduced, I think last week in New York, that talks about only the outputs of large language models that give advice like lawyers or doctors. I'll tell you which one of those I like better. So I think there's something there. And maybe an example of that. I don't think I've ever said this before. So you're the first person to hear this thought, and that means it might be wrong. But there's a longstanding debate in products liability law about whether software is or is not a product. And that matters a lot. We don't know that. It's been forever we've been making software and we don't know whether it's a product. And yet, I imagine that's the sort of area where a really targeted legislative action that said, oh, by the way, software is a product for purposes of product liability law, we'd get some clarity and it would immediately kind of trigger the power of courts to help to navigate this area. So I like the idea of the question, even though I'm worried about particular applications. Yeah.
Yeah, I'm curious like how you address like some of the deficits when like you're applying these old tools to new technologies. I'm thinking of like the case of like Free Speech Coalition versus like Paxton. The court's opinion, I think, uses a lot of traditional First Amendment doctrine, thinking around regulation of like cable TV. I know during oral arguments, like Justice Thomas talked about like analogy of like showing your ID when you're buying alcohol. Sometimes I'm worried like these analogies that they focus like too much on the similarities to the sort of detriment of like the differences. And I think in that particular case, like the differences being around digital identifications and the privacy risks that are unique. So I think there's some usefulness in like looking at the similarities, but how do you sort of address like when those analogies sort of overlook the differences that the old tools don't necessarily address?
So this is another question where I have to say I'm not sure I can give you an answer, but maybe I can give you some thoughts that might help. The reasoning by analogy that's so common for judges and lawyers is very useful in the sense that when you're deciding a new case or thinking about something new, you don't have to like start with the idea of justice and reason from justice out to the result in this case. You get a lot of help. You say, well, hitting someone with a sword, that's kind of like hitting somebody with a hatchet. I guess we shouldn't allow that either. And so really helpful to not need to start at the beginning every time you're trying to resolve a dispute. Also encourages treating like cases alike, kind of a fundamental principle of common law jurisprudence. But on the other hand, we can be led astray by that, by kind of the appearance of a superficial analogy where maybe the facts seem similar, but the underlying logic doesn't actually translate. And so I won't point you to it because it's not so good as to be worth reading. But I wrote a piece about this recently, when I say recently, a couple of years ago, about the limits of analogical reasoning in the law. And that's my fear too, is that sometimes judges can get into the habit, a very good one, of borrowing and reasoning by analogy to the point where they miss important distinctions. And so there's this danger to reasoning by analogy also. But that didn't answer your question. It just rephrased it in the way I think about it. So maybe helpful, maybe not. Yeah.
Okay, so we're focused a lot on the common law, so answer this as you will, but we've talked a lot about the First Amendment, like we do a lot of work here at the First Amendment around like constitutional issues, specifically like free speech, freedom of religion. And I think that there's kind of this debate right now of within the world of AI, I guess generally like advanced technologies of like should like we not limit AI because that actually we need to protect the free speech that AI is. And on the other hand, it's like, but AI can harm other constitutional rights, like the freedom from discrimination or other issues. So I guess, I don't know if you've thought a lot about this, but if you have, could you speak kind of to the uses, like, there's these advancing technologies and the interplay of those technologies with the existing tools that we have in sort of the constitutional rights world.
Yeah, I can give you a few thoughts about that. And so I guess the key point, nobody objects to this, but it's sometimes important to think about it. The freedom of the press doesn't mean you have to go buy a printing press. It has to be expandable to other similar technologies where you also have a right to communicate in certain other ways that aren't just the press. And so I just want to concede that and emphasize it. The problem then is figuring out what exactly is speech, what exactly is going to count versus not. The key area where I run into this in my own research about 230, actually, section 230, is when you start having online platforms that want to make First Amendment arguments or maybe use a First Amendment argument to bring in section 230, they'll say, well, my algorithmic curation decisions about which content to place in which order, for instance, on a news feed, that's speech. And I'm torn on that because when I think about the analogy, to go back to the point about analogies, the curation algorithm, the decision about where to place what in your news feed, that's kind of like the New York Times or to the extent we still have magazines deciding where on the page to put things. It feels a bit like that by analogy. But once it's an algorithm, and a very large algorithm that is doing so much work that really even the person who programmed it, could they see all of the content, still wouldn't really have much sense of how it was going to come out. I start to wonder if that's really the same thing as arranging articles on a page anymore. And I start to bring in a different analogy. I start to think, well, it feels more like you've got a kaleidoscope or some kind of product that's like arranging the articles in the way that a machine does. Maybe there ought to be some sort of products liability available there. And so that's a point of struggle for me. I tend to come down on the side of thinking mass algorithmic curation decisions don't feel like speech to me, but I could be persuaded because I find that to be a tremendously difficult point, and maybe the sort of case that you were thinking about too. At least it's the one that keeps me up.
I think we have time for one more question.
Yeah.
Yeah, so my question is about, there's currently a case before Supreme Court in Charles v. Salazar on this ban from Colorado on counselors who give talk therapy related to conversion therapy. So with people now using AI as like a friend, a counselor, what kind of issues could we run into that? Whether, I don't know, AI could have any like First Amendment rights, or how can the state try to protect kids or like people from, you know, conversion therapy or this kind of like the same issues that they're concerned with this counselor in Childs?
Yeah. So I should preface this by saying I am not a First Amendment expert. I'm somebody who loves tech and who loves figuring out how to regulate it without killing it, which often involves speech. But as far as First Amendment doctrine, I'm not going to be the one you want to talk to first. But I'm also a lawyer, so that means I'm willing to talk anytime anybody wants me to talk. And so I'll tell you what I think. I think about the LLM output a little bit like I think about the curation decision output of a curation algorithm inside a news feed. That's pretty hard for the designer of an LLM to really have much control over what exactly is going to come out of the LLM. So I don't think of it as very speechy. It feels more like a product to me that ought to be controlled by relatively unmodified products liability law. But I could imagine all kinds of situations, for instance, image generation, content creation that has like some artistic flair added to it. All of a sudden you're in the world where it feels like speech again. And so these things feel really complicated to me. But my initial thought is, boy, that LLM output, at least the raw output, doesn't feel like speech. But when it's an actual therapist, the Supreme Court's wording in its grant of certiorari feels like they think it's speech, although I don't think that case has been resolved yet.
Okay, please join me in thanking Professor Dickinson.